I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. Today is Wednesday, December 15th, 2021. The time is 1:44 in the afternoon. This hearing has been being conducted virtually. It is available for viewing live via the chairman's website, which is www.chairmanmendelson.com/live. The hearing is also being recorded and will be available on the council's website in the near future, and that address is www.dccouncil.us. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. The subject of today's hearing is Bill 24-135. This bill was introduced on March 1st of this year. It is entitled the Non-Public Student Educational Continuity Amendment Act of 2021. Stated purpose of this bill is to allow students who were under the care of the district, but who have been placed in the permanent care and custody of a parent or guardian or custodian, a parent, guardian, or custodian who resides outside of the district, to allow those students to remain in their non-public school or program and to have the district pay for that placement. I'll say tuition, to pay for that placement for the remainder of the school year, as well as the following school year. The permanent version of the legislation, that's the bill before us, mirrors 3 rounds of emergency and temporary legislation that have been approved by the council last year and into this year. Fairly simple purpose to the bill. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on December 29th. We have 3 non-government witnesses whom I will ask to testify first, and then we will turn to the government witness. Allison Kahn-Pauley, who's with CASA for Children of DC. Danielle Robinette, who's with the Children's Law Center, and Raymond Mendoza, who is language acquisition teacher in the District of Columbia Public Schools. Let's begin with Miss Allison Kahn-Pauley. And I don't know that I have, hope my staff is getting the statements now. Ms. Kahn-Pauley, why don't you begin?
Good afternoon, DC Council members. Council Chairman Mendelson, thank you for this opportunity to testify. My name is Allison Kahn-Pauley, and I am the Chief of Staff at CASA for Children of DC. For nearly 20 years, CASA DC has advocated for the best interests of foster youth in the District of Columbia. We have provided volunteer advocates to over 1,900 youth, helping foster children to achieve permanency and better outcomes, particularly in education. Today, we are turning our advocacy to voice support for the Non-Public Educational Continuity Amendment Act of 2021. Education is an area of significant challenge for foster youth. They are often at a greater educational disadvantage compared to youth in the general population, compounded by the trauma that they have experienced and the instability of the foster care system. They are less likely to graduate from high school or college. Just 3% of foster youth obtain a college degree. Nationally, and in the district, child welfare-involved youth consistently perform lower in math and reading achievement. In 2021, less than 26% of DC's child welfare-involved youth were approaching at or exceeding expectations in math or English. Fortunately, interventions can help. With the support of a CASA volunteer, 88% of our youth in 2021 were approaching expectations in school or greater. Our youth had an average GPA of 2.6 compared to 1.9 for the average DC child welfare-involved youth. There are many factors that can be addressed to improve educational outcomes for foster youth. We know that for foster youth, the traumatic impact of abuse and neglect places children at risk of developmental challenges, including impacted cognitive functioning and learning, leading to lower academic achievement. This is exacerbated by mental health challenges that may worsen foster youth's educational struggles. But there's another key factor that jeopardizes foster youth's academic success: school change. Youth in foster care experience significant instability, not only through being removed from their homes, but also experiencing placement change. With placement change, foster youth are often faced with school change, and with every move, it is estimated that 4 to 6 months of academic progress is lost. School change brings a disruption in supportive relationships and discontinuity in course content, hindering learning progress. While achieving permanency is the ultimate goal for children in foster care, when that permanency necessitates school change, it continues the threat to youth's educational success by perpetuating further instability. CASA DC applauds efforts that the district has taken to safeguard educational stability for foster youth, both through CFSA's implementation of the Every Student Succeeds Act for Youth in Foster Care and the Educational Continuity Amendment of 2014, allowing youth who have achieved permanency outside of the district to continue attending their DC public school. However, that act did not cover non-public schools or programs. Temporary legislation has sought to reconcile this gap since 2020. The Non-Public Educational Continuity Amendment Act of 2021 would allow the support to continue for non-public youth. As best interest advocates for foster youth, CASA DC supports this act. Together with supportive legislation, public agencies, and nonprofit organizations working together, the District of Columbia can continue working to improve educational outcomes for foster youth. Thank you.
Thank you, Ms. Khan-Polly. I hesitated for a second. I thought I was muted. Danielle Robinette.
Good afternoon, Chairman Mendelson and members of the committee. My name is Danielle Robinette. I'm a policy attorney at Children's Law Center, a resident of Ward 6, and prior to law school, I was a public school teacher. I am testifying today on behalf of the Children's Law Center, which fights so every DC child can grow up with a stable family, good health, and a quality education. Children's Law Center reaches 1 out of every 9 children in DC's poorest neighborhoods, more than 5,000 children and families each year. Thank you for the opportunity to testify today in support of the Non-Public Student Educational Continuity Amendment Act of 2021. This bill addresses the crucial educational needs of students at the margins of the margins. While a series of emergency and temporary bills have protected this vulnerable group of students in recent years, we appreciate the committee for working to make this solution permanent. The Act makes a small but important change to DC Code Section 38302E that would, if passed, expand the definition of resident for the purposes of assessing tuition for students who live outside the district while enrolled in a DCPS or public charter school. Traditionally, DC students who reside outside the district are charged tuition. However, Code Section 38302E creates an exception for students in the care and custody of the District of Columbia who cease to be in that care due to an establishment of permanency outside the district. In other words, a child in foster care who achieves permanency outside of DC through adoption, guardianship, or a custody agreement is permitted to continue attending their DC school through the end of that school's educational program without triggering the requirement of tuition. This code section is crucial to ensuring that educational continuity does not conflict with permanency for students in foster care. This provision is particularly important in the DC context as CFSA places roughly 50% of children in their care outside of DC. Since the 2015 edition of Section 38302E in the district's non-resident tuition law, a gap has surfaced for students in care who are enrolled in a DCPS or public charter school, but attend a non-public school. For students with disabilities, there are cases in which their public school cannot meet the educational needs outlined in the student's IEP. In such cases, the student's IEP team may determine that the most appropriate placement for that student is a non-public school. When a non-public school is warranted, the student's public school of origin is responsible for paying the student's tuition at the non-public school. However, when a student in foster care has special education needs so significant that they require a non-public school, DC Code 38302E lacked the clarity needed to ensure that DC continued to pay the student's non-public tuition in cases when the student achieves permanency outside the district. This lack of clarity in the law led DC LEAs to decline to pay the non-public tuition for students who achieved permanency outside of DC. While 38302E required that the student be allowed to finish the education program at their DC public or public charter school, LEAs did not interpret this to mean that they were obligated to pay the student's non-public tuition. This interpretation created several perverse incentives for students and their families having to navigate the complexities of both the foster care system and the special education system. For many families, paying tens of thousands of dollars in non-public tuition is simply not feasible. In these situations, families were forced to choose between achieving permanency or maintaining their students' placement in the setting best suited to meet their educational needs. In early 2020, when the council learned of this gap in the law, it passed emergency and temporary legislation that amended 38302E to clarify that students enrolled in a DC public or public charter school but attending a non-public school are considered residents for the purposes of assessing tuition. Further, it amended the code to specify that this exception applies to the remainder of the school year in which the change in care and custody occurs and through the end of the following school year. These two amendments provide both immediate educational continuity and a reasonable timeline by which families can transition to alternative arrangements for their students. This temporary fix has needed to be renewed multiple times over the last 2 years. While these temporary fixes have ensured financial and educational stability for these students during a tumultuous period, it is not a sustainable solution. As each new expiration date approaches, families worry that they will unexpectedly be on the hook for an expensive tuition bill. For these reasons, we appreciate the council's work to make this legislative fix permanent. Passage of Bill 24-135 will provide families with a clear right to educational continuity for their student, as well as a timeline by which they can plan for their student's educational future. Thank you for this opportunity to testify, and I welcome any questions.
Thank you, Ms. Robinette. Do we have a copy of your statement?
You should. I sent it yesterday. I can send it again if necessary.
Would you please?
Mhm.
So let me ask both you and Ms. Conpoli, do you have a sense of how many children we're talking about?
We tried to guess kind of based on our client population, and it's very few. I would say probably less than a handful each year.
Ms. Conpoli, do you have a sense?
Would echo that. I do not have a specific number from our youth. I know that it is very few, but it is still a very important population to address and ensure not falling through the cracks.
Yeah, I would want to echo that point that while it is very few students, the burden that it places on those students is significant, tens of thousands of dollars a year.
Sure, and you made that point in your statement. No, just trying to get a sense of how many children we're talking about. And to both of you, did you look closely at the legislative language, and do you think the legislative language is fine?
I would say yes, given that the language in the permanent bill mirrors the emergency and temporary, which has seemed to work since the first emergency in early 2020. We haven't seen issues.
Yes, and I would echo that.
Just looking to see if I have any other questions. I think that's it. I appreciate your testimony. Ms. Robinette, if you'd send your statement again, send it to cow@dccouncil.us. Both of you, your statements are helpful. I don't think this is a controversial bill, but it's helpful to have a good legislative record behind it. So you're each excused. The other non-public witness, non-government witness is Raymond Mendoza, but I don't see him here. So I'm going to turn to the government witness, Sarah Jane Forman, who's General Counsel at the Office of the State Superintendent.
Good afternoon, Chairman Mendelson.
Good afternoon. When you're ready, why don't you begin?
Okay, great. Good afternoon, Chairman and members of the Committee of the Whole. My name is Sarah Jane Forman, and I am the General Counsel for the Office of the State Superintendent of Education. I am pleased to appear before you today for this public hearing on Bill 24-135, the Non-Public Student Educational Continuity Amendment Act of 2021. It is important that children in the custody of the District of Columbia obtain the educational services for which they are entitled to, no matter their custodial arrangement. In some circumstances, a child formerly in the care of the district may be placed in permanent care and custody of a parent, guardian, or custodian who resides outside of the District of Columbia. Children with non-resident parents or guardians may not attend public schools in the district without paying tuition. Yet, local law provides some exceptions. And one such exception is a case when a child's custody changes from status of ward of the district to a parent or guardian that is a non-resident. If the child attends a District of Columbia public school or public charter school, the district pays tuition until the child completes the educational program offered at the school. However, the law does not address tuition payments for students attending non-public special education schools. This is the issue that the legislation before the committee today seeks to address. Allow me to provide some background on student placements into non-public schools for context. The Individuals with Disabilities in Education Act, IDEA, requires children ages 3 to 22 to receive special education services that are documented in an individualized education program, or IEP. IDEA mandates that, to the extent appropriate, all children with disabilities be educated with their non-disabled peers in the least restrictive environment. Yet, there may be instances where the nature and severity of a child's disability warrants a more restrictive placement. Although local education agencies should always consider placement in the general population classroom within a DC school before considering a more restrictive setting, there may be instances where a more restrictive placement is appropriate. Changes in placement must be made consistent with OSSE's policies, and an IEP team makes the decision to place the child in a more restrictive environment outside of the District of Columbia. Non-public special education schools or programs are privately owned or operated schools that maintain or conduct classes for the purposes of offering instruction to students with disabilities. Non-public schools or programs are responsible for maintaining a full certificate of approval, or COA, from OSSE, and must follow all applicable laws, submit annual compliance reports, and participate in on-site monitoring visits by OSSE. OSSE provides tuition payments to non-public schools for services provided to district resident students that attend those schools. Yet, when a student has non-resident parents, it is the parents or guardians that pay the tuition, not the district. And in situations where the custodial arrangement shifts from the district to a non-resident parent, that non-resident parent would thus be required to make the tuition payments under existing permanent law, as discussed by the witnesses before. The council has created a remedy to address the situation through emergency and temporary legislation, and the Non-Public Student Educational Continuity Amendment Act of 2021 would make previous emergency and temporary legislation permanent. The bill would allow students that go from being in the care of the District of Columbia to the permanent care and custody of a parent outside of the district with the ability to stay enrolled in a non-public school until the end of the school year in which the change in care or custody occurs and through the end of the following school year. During that time, the district would pay for the tuition of these students. OSSE supports this legislation. The situation described above that the bill seeks to address occurs rarely and impacts a very small number of children. Further, without a permanent statutory change, OSSE does not otherwise have the authority to pay tuition for students in this situation at non-public schools. These students would be found to be non-residents under existing law. Further, we do not want to deter the adoption and placement of some of the district's most vulnerable children on these grounds. These custodial arrangements are sensitive, and gaps in educational services, especially for students with unique learning needs, could add additional burden on adoptive families. That's not our intent, and continued authority to provide these tuition payments ensures educational continuity and reduces some of that burden on students and families. We appreciate the council's effort to make this legislation permanent. We believe that it is an important correction to support some of the district's most vulnerable children. Thank you for affording me the opportunity to testify before you today. I am prepared to answer any questions you may have.
Thank you, Ms. Forman. I just have a couple of questions. How closely did you look at the legislative language, and do we have the legislative language correct?
I have had an opportunity to review it. So has my team here, and we think this is the correct language.
Okay, and I believe it's similar to the emergency, and there's been no problems with the language in the emergency.
Exactly.
And do you know how many children are affected? You said a few or rare, rarely in a
Yes.
very small number of children.
It is a small number of children. It is an N size less than 10. So for student privacy reasons, I will not disclose the exact number, but it is a small number. And if you'd like to have a more private offline conversation about it, we could do that.
No, I don't need to. When we first did the emergency, there was a concern about a fiscal impact. There are, let's say, 10 kids. Why isn't there a fiscal impact? Because you've been paying this and therefore the cost is included in the budget?
Yes, correct. It's in our non-public budget, which we budget for in advance as part of our agency budget.
And are we talking about $10,000 per kid per year, $20,000? I guess it probably varies depending upon the special ed level, but roughly what are we talking about?
It could vary because the placements can vary, right? So some schools are more expensive than others. Some students may be in out-of-state schools. Some students may be, in local private schools. So the cost does vary significantly. So from year to year, depending on the students to whom this applies, that number could change. But we do know in advance and can budget for it ahead of time.
Okay. How about the number? So you said the N is less than 10. Does that number fluctuate very much?
Not for this population of students who are transferring from being wards of the district to an adoptive placement, permanent placement.
Let me just see if I have any other questions. I don't think I have any other questions. We're probably going to mark this up in January, but we have the emergency and temporary that I think we just did another round, so we should be covered by that for a while.
Correct.
I think I'm going to leave it at that. Thank you for your testimony, and thank you for OSU's support with this. I'm going to close out the hearing. This has been a hearing on Bill 24-135, Non-Public Student Educational Continuity Amendment Act of 2021. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on December 29th, 2021. I do want to apologize. I kept everybody waiting. It was because of this other meeting. The time is now